Price.
Well, Lords, just one small point. I don't want to get too hung up on the question of the late amendment of the reply, but it's a point that Lord Mance has reminded me of on more than one occasion. And very briefly, there are 2 points to be made about it. We complained from the start of the whole publication, print and web. So the complaint throughout covered the pre and post cut-off point. That left the onus on the defendant to find some form of defence to that, in particular a Reynolds defence. And since they didn't make any distinction in their pleading as the pre and post cut-off point, they were, in a sense, naked in the chamber as regards the post cut-off point. It was no doubt good practice for us in a reply to point that out, but in reality, the pleading of a defence to that part of the publication was up to the defendant. If anybody's queries whether the Times was aware of its obligations, if it wished to continue to run a Reynolds defence, the answer to that is that it clearly was. I needn't ask your lordships to turn this up, because we've looked at this letter several times. The reference is in the appendix at tab 7, page 171. It's the 14th of September letter, shortly after the cut-off point.
Thank you.
And at the very bottom of page 171, Mr. Brett, the Times newspaper, says, moving on to what I would now call the Times' Reynolds' obligation to carry a report. While that obligation was not fulfilled, for reasons that may have become apparent from the later correspondence. My Lords, I think that's really all I need do with the correspondence. What it shows is...
Did they issue any sort of notice anywhere? Just remind me.
I beg your pardon?
Did they issue any sort of notice anywhere, or was it just on the web that they didn't at this stage?
At that stage, I think they did nothing, except that I think I'm right in saying that on the web, there was a notice to the effect that it was subject to litigation.
Yes.
Which I think they suggested to Mr. Justice Tugendhat that that notified the readers that Mr. Flood took objection to it, and Mr. Justice Tugendhat said he wasn't prepared to accept that because it didn't say, because there were more than one person who could have taken objection to it. But there was no report at all of the exoneration in the result of the police inquiry, which is a somewhat remarkable situation, given that they'd seen it as in the public interest. The public should be told at the commencement of the inquiry. It raises the question, well, why isn't it in the public interest that the conclusion of the inquiry should be reported? But at all events, it was not until after the judgment at the Reynolds trial, when it became apparent that that they were in trouble.
Is the inference that they simply failed to realise that there was material on the web because they recognised that there was? What is the position?
Well, I think the position is twofold. First of all, that the Times journalists didn't think that the result of the police investigation added anything to anything. That's point one. And point two, the Times legal manager thought that he'd done enough by offering an update, as we say, and clearly so, as part of an overall settlement, and that he didn't then actually have to do anything about actually publishing it. I think that's why it happened.
Yeah.
So, I mean, the net result of all this is that if one asks the questions, could the Times have settled the action, on terms which fully preserved its public interest journalism in the pre-cut-off period? The answer is plainly yes, at some point before the main costs were incurred, namely the Reynolds trial. And that is why Lord Justice Sharp, in her judgment, the Court of Appeal said, well, they obviously could have either settled it or offered to do so. In fact, it's fair to describe what was done as goading the respondent, particularly by amending to justify on a basis that made it look as if the real allegation was that he was probably guilty.
Yep.
So that, I think, is all I need say about the correspondence. So turning to the question as to whether it's submitted that the Reynolds trial would have been unnecessary if the respondent had conceded the Reynolds defence to the pre-cut-off publication. Well, the answer to that is given by Mr. Justice Tugendhat. The reference, my Lord Hodge referred to that a little earlier. What Mr. Justice Tugendhat said is quoted in paragraph 28 of our case, and I needn't take your lordships to it. The reference is in the appendix at tab 12, pages 371 to 2. He says that, having regard to the way the matter has been contested, I see no reason to doubt that the defendant would have conducted the trial very substantially, if not identically, to the way in which they did, even if the claimant had conceded qualified privilege up to the cut-off point.
What page was that again?
I beg your pardon. It's
371.
371 to 2.
At the bottom of 371.
Oh, I see. The very, very last thing. Yes, I see.
What's happening here is...
That was taken up subsequently, wasn't it? That was taken up subsequently, both by Mrs. Justice Nicola Davis and in the Court of Appeal.
Yeah.
Yes. In fact, what's happening here on page 371, it's almost impossible to see the page number, but that's what it is that Mr. Justice Tugendhat has just heard a fairly lengthy argument on costs at the end of the Reynolds trial. Mr. Rampton saying, well, we've substantially won the Reynolds trial, and so we ought to have the costs. And Mr. Justice Tugendhat, this is Mr. Justice Tugendhat's judgment, in effect. And then the relevant passage is at the bottom of the page.
Thank you.
My learned friend submits that he can't have meant that he says that in his case. But he obviously did mean it. I mean, he couldn't mean anything else. He'd seen the trial. He saw the way in which the Times was approaching this, which your lordship has seen in the correspondence. He was quite entitled to take that view. If we'd conceded the pre-cut-off Reynolds privilege, it would have been on the basis, sensibly, it would have been on the basis that, well, they reported a police investigation, and the fact is there was a police investigation. That would have got the Times absolutely nowhere in trying to persuade a court that there was a Reynolds privilege for the post-cut-off time. Essentially all the evidence that was brought forward at the trial would have to be brought forward in order to convince the judge that there was still a pressing need for a proper inquiry. The Times simply never made any distinction in its argument in the course of the Reynolds trial between the pre- and post-cut-off date.
Yeah, can we just pursue that? Why do you say all the evidence would have had to have been brought forward? I thought that it seems to have failed quite shortly, the post-cut-off defence in the judge's judgment.
Yes, but that's right. But that was, but he'd already heard all the evidence, and so he was in a position to judge whether the the evidence was good enough, and he held that it was not good enough to overcome the fact that the police inquiry had finished.
Well, basically, what material was relied upon to justify continued publication of anything after the investigation? I'm just looking to find where that material is identified and where it's analysed, because at the moment, just looking at the judgment, it seemed on the substance at tab 11, it seems to have gone almost without saying that once the result of the investigation emerged, there was nothing the Times could set up. I may be wrong, it may be somewhere in the judgment that serious issues still remained, which required exactly the same evidence.
Well, in the Times's case that they presented in their evidence, they simply didn't make any distinction. As I say, they said there was a pressing need for inquiry. What the journalist's motivation was to persuade the police to do a proper inquiry because he thought they wouldn't. And then no distinction was drawn. I think insofar as there was any separate argument as regards the post-cut-off point, if I remember rightly, it related to the offer of an update, which was said to...
Yes, he demolishes that. The judge deals with that. Paragraphs 244 on.
Yes.
I mean, obviously, Mr. Justice Tugendhat's probably much the best person to judge at the time, but I am just a little puzzled as to why he thought that the whole trial would have gone ahead with the same evidence when the judge appears to have thought the evidence almost automatically didn't address the post-investigation result seen.
It didn't address it. He clearly didn't think it was enough to justify it.
I see.
But I mean, he had seen the way in which the case was fought, and it was fought on the footing that there was that the matter needed investigating, and that the investigation that was done was not that investigation. So I mean, when the point separately arose, my learned friend tried to persuade the judge that the offer of an update was good enough, and of course the judge wasn't having that. I mean,
is paragraph 234, which I just have lit upon, an example of the sort of thing that the judge may have had in mind, or is it?
I think it probably is, yes. There was, I think, trying to put it in as neutral language as possible.
Even if rejected, yes.
Putting it as neutral as possible. Mr. Gillard was pretty committed to the view that there was at the least a serious smell here.
So basically, despite what one might think the correspondence, what the correspondent said, the Times was arguing there's nothing to cause us to change our mind in the result of the investigation, and all the evidence is still material. There's ground for suspicion that the investigation isn't a proper one, and the website publications for the rest of the period are justified.
Well, I think that's probably a fair summary of it.
Yeah. Fine.
It's interesting to note the way in which the Times reported the Reynolds trial. There was no report of the Reynolds trial except of Mr. Gillard's evidence to the effect that the police had done an inadequate job in investigating it. It's a hypothetical question, but Mr. Justice Tugendhat clearly formed a view. and he expressed it. My learned friend devoted some attention to the disparity in numbers between the publications before the cut-off date and the publications post the cut-off date. And as it stands, that is, of course, rather striking. But in our submission, that ignores the reality of web publications in this day and age. And if I could just show your lordships what both Mr. Justice Tugendhat and Lord Justice Sharp, who are experts in this field, said about it. It's in the Court of Appeal judgment, Appendix 4, Appendix Tab 4. I have it in a different. Paragraph 26 on page 148. It's perhaps quickest if your lordships just read that quickly to yourselves.
Which paragraph?
It's paragraph 26 on page 148.
Yes. Yes, we looked at that, yeah.
Yes.
Heading the imprimatur of the Court of Appeal. Yep, thank you.
Yes. The truth is that, I mean, where a print publication is concerned, if someone's not already a celebrity or well known, anybody reading it, if you ask them the next day who was that story about, they probably couldn't give you the name. What matters is people who are interested in it, or particularly people who are searching you on Google, and they find this.
Well, all people who know you, presumably. Or people who know the subject.
Of course, that matters tremendously. So it's not a numbers game. There were some examples given in the damages judgment. I've given the reference in paragraph 34 of the case of comeback to Mr. Flood. There was evidence about this at the damages trial from police officers who had looked him up on the internet and saw the article unqualified. In the end, our submission simply is there were four principal factors that the judge had to hold in the balance. There is no doubt that my learned friend's success on a significant part of the Reynolds defence was a highly significant factor. The judge gave the closest attention to it, coming back and back to it. But essentially, my learned friend has to satisfy your lordships that it was decisive and that no reasonable judge could reach any other conclusion. And my learned friend does not shrink from making that submission.
But I think your position is that unless the Times gets through the threshold of perversity on the information in front of her at the time, then we don't need to review the matter at all.
Yes. 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 And essentially, I think my learned friend accepts that, as far as I can see. Lords, I don't think I need to say any more on the first part of the appeal, so I can move on to the additional liabilities. Just by way of introduction, your lordships are very well aware that in the Lawrence case, the 1999 scheme has been held generally compatible with Article 6 rights of claimants and defendants. Nobody seeks to challenge that judgment. The issue is only, does it make the decisive difference where the defendant's Article 10 right is engaged, and on the footing that the scheme is capable of chilling media publication. It's capable of chilling media publication because of the effect on Article 6. Defendants who are sued or are afraid of being sued are worried that they will not have access to court because the consequences are too grave, and that the indirect effect of that is that they then may become more reluctant to publish. There is, in fact, no evidence that this effect is actually working, and given the amount of time for which the scheme has been in operation, that is, to say the least, a little surprising. It may be anecdotal evidence, but on the evidence of the cases before your lordships, and in particular the flood case, there is not the slightest indication that the defendant was in any way deterred from exercising its, either its Article 8 right or its Article 6 right.
Not in that case.
No. I accept that, that's anecdotal, but the
I think
truth...
we must take it, surely as a matter of common sense, as the European Court of Human Rights took it. There must be a chilling effect, at least for some sections of the media. If you're a small newspaper, you wouldn't go near these sums of money with a...
Well, that may be so, but where's the evidence of it? If you're,
You have to have evidence for that, do you?
if you're a small newspaper, I'm not sure I've got the figures right, but I think over 80% of the local press is owned by national newspaper groups. So they are essentially in the same position as the national newspaper groups. You
think that the sort of the Taunton Record can happily accept a £2 million cost burden just because it's got a rich parent? I wonder if it looks like that from head office.
Well, they won't be too keen, obviously. The legal
Taunton
department.
Record would probably last about a day.
The local press, which is not owned by national newspaper groups, carry insurance, and they would be mad not to do so. That's the reality.
The insurance premium will reflect the risk.
Well, I've no doubt that's right, yes.
And insurance premiums become intolerable at a certain point.
Well, again, I mean, it would be nice to have evidence on this, but there we are. But the other aspect of this is that the cases that your lordships are considering, publication cases, defamation and privacy cases, are different from the cases covered by Lawrence in two respects. One, the Article 10 rights are engaged, but so are the Article 8 rights. The Article 8 right is engaged in exactly the same way, because a claimant is faced with his Article 6 problem, namely, shall I have access to court? And if he can't find a lawyer to act for him, and he can't afford a lawyer, he has no equality of arms. And perhaps even more to the point, even if he can find a lawyer to act for him, he can't possibly take the risk of suing without ATE insurance, because he would be ruined by the costs if he were to lose. So there are both these rights are in play. The history of the inquiries, of the consultations, and so forth into this shows that striking that balance is intensely difficult and intensely controversial. So I mean, that's the background to it. Our principal submissions, we've divided up the task in a way which I will explain to your lordships in a moment, are that MGN and UK does not decide that every case of recoverable additional liabilities is non-compliant. It simply rejects the notion that it is a compliant general scheme which can save even hard cases. It doesn't follow that every case is non-compliant. The second...
So you say it's, in a sense, a two-stage process. If you'd established the scheme in principle was okay, then you wouldn't even look at the facts of the particular case.
Exactly.
If you decide the scheme is not acceptable generally, then you have to look at the particular case.
Exactly.
Yes.
Yes.
And only if you
it
get
doesn't
over,
follow
only
that-
if the person complaining gets over both hurdles do they get anywhere. That's your point, is it?
Well, I think my point is that if the scheme is held not generally compliant, so as to save every case, well, then you have to move on to the second stage. My learned friends would say that's the end of it. You don't even get to look at the individual facts. So that's our first principle submission. The second one is that MGN and the United Kingdom is not part of a consistent line of Strasbourg jurisprudence, and that its reasoning is flawed because of its failure to take into account the demands of Article 8, which may reflect the facts of the case and the way in which the case was put. Thirdly, we say that it's critically important to notice that the decision was driven, as one might say, by a lengthy review in the judgment of the consultations, the inquiries, the governmental decisions that had preceded the case. In particular, of course, the Jackson report, Lord Justice Jackson's report, and the government's decision to accept it and to cap fees at 10%. That really is what appears to have driven the decision. We say that the landscape has shifted entirely since then, and that if the Strasbourg court were now looking at the position and giving the same respect that it does to consultations, inquiries, governmental decisions, and so forth, and the present-day policy context, it would reach the opposite conclusion. And the fourth, final point relates to legitimate expectations as protected possessions. The division of responsibilities is that I'm now going to take your lordships through the context in which MGN in UK was decided and developments since then. My learned friend, Mr. McCormick, is going to deal with the following points. For what is Campbell v. MGN in the House of Lords authority? Secondly, what does MGN and UK actually decide? Third, should it be followed? And fourth, he's going to make some general points on legitimate expectation. My learned friend, Mr. Tomlinson, is going to consider developments since Jackson, Lord Justice Jackson's report on MGN in costs management and assessment, and how they have affected the four flaws, cost budgeting and matters of that kind. Second, whether the 1999 scheme is now compatible. That is the balance between the various articles that are in play as matters now stand. And then he's going to make some general points on remedy.
Why does it matter whether they're now compatible? I mean, if we're dealing with historic costs?
Well, whether your lordships would take the view that they were now compatible, but that your lordships were going to declare the cost orders in the present case unlawful because of the timing is problematic. I may have to come back to that.
What's the problem? What is the problem?
Well, I think the point that that my lord is putting to me, that if, as a result of the policy context as of today, the scheme is to be regarded as compatible, will that save us if our CFAs were entered into a long time ago?
That the answer to that must be it make no difference, surely. Are you submitting that one should not treat the result of the historic position as relevant if it's been rectified since?
Well, it would be curious if this court were to strike down some CFAs which were entered into.
Not at all. We usually decide cases on their facts as they existed, not in the light of changes which might affect other cases.
Well, it may be difficult for your lordships because your lordship may have to decide at what point in the history the system became compliant.
But clearly, Mr. Thomason will have an interest in the more recent developments, even if your clients do not.
Well, that may be
Your
right.
client does
Yes.
not. Yes.
I mean, in a sense, if you demonstrate striking improvements, that may count against you if you're wrong on your primary position.
I think we'll see this as we go through the history of it, but I think what really has happened is that it has been realised since
Yes.
MGN in UK how pressing is the need, at any rate in the United Kingdom, in England and Wales, for access to justice in publication cases. That was insufficiently appreciated at the time the case was decided. So it may be that what has happened since has altered the landscape. At all events, my lords, I will...
Difference, isn't it, Mr. McCormick, between altering the landscape in the sense of appreciating something that was always there but not
Yes.
spotted, and altering the landscape in the sense of putting in alternative, partially approved schemes.
Yes.
That's clearly a subsequent fact.
Yes.
But I think what you're suggesting, Mr. Thompson, may be going to tell us about is the first.
In a sense also the reluctance of the national press to take up the offer of a scheme which would entirely relieve them of this massive burden.
They may have some very principled objection based on independence of
well, they may have.
administration. And
I think a reading of Lord Justice Leveson's report, I'm not suggesting that Lordship should read all 2,000 pages of it in the next few days. A reading of Lord Justice Leveson's report would suggest that that may not be so. At all events,
that would ask us to try the regulation question. We're going to need another week, aren't we?
Yes, but your lordships will see both how pressing is the need for access to justice and both how difficult it is to strike the balance. Your lordships' problem essentially is that you're presented with the choice of either upholding the scheme or striking it down. You're between the devil and the deep, if I can put it in that way, because if you leave the scheme where it is, well then according to my learned friends, the law of England and Wales will be in breach of Article 10. But if you strike it down, there seems to be very little doubt that the law of England and Wales will be in breach of Article 8. So there's a problem either way. Essentially, it's not a conundrum that can be resolved by judicial decision. It's a legislative matter because your lordships, unfortunately, if your lordships were to come up with a scheme which will balance these rights, you will have done better than anyone else who's tried it. But that is really a legislative matter, not a matter for judicial decision. Lords, I better move on to the to developments since what led up to MGN in UK. I'm not going to spend much time on that because that, as your lordships would have read the judgment and will no doubt read it again, it's covered at considerable length in the judgment. It's actually done twice. It's done at paragraphs 100 to 120 and at paragraphs 203 to 215. And there your lordships will find how the matter appeared as at the end of 2010. And it shows the weight that the court places on those processes. It ends rather abruptly at paragraph 120, with the court simply observing that the government's then solution of reducing success fees to 10% was not maintained in the run-up to the 2010 election. And if I can just show your lordship what actually happened to the proposed regulations, which I can do very quickly. If your lordships would go to volume 4 at tab 33. This starts on page 1337.
Yep.
Where one sees that it's headed damages-based agreements regulations, but one sees from the first paragraph that the minister is also speaking to the conditional fee agreements amendment order, which is what was going to reduce it to 10%. And the passages I wanted to read to you are from Lord Wolfe spoke in the debate. That's at paragraph 1344. And he gave a little history of how conditional fee agreements had and additional liabilities had come to where they were. And on page 1345, the first column, just below the middle, he said, "I'm certainly not happy with the position with regard to costs in defamation proceedings at the moment, but I question whether the dangers of reducing the uplift from 100% to a maximum of 10% could not have very damaging effects on the other party to litigation, in addition to the media, which has an interest that needs protecting by the courts." The noble lord who introduced it, who I think had some personal experience of this, made it clear that the personal consequences of not being able to bring proceedings, which could be the result of a 10% cap, can be very serious indeed to the citizen, more serious, if I may say so, than the harm that would be caused to the press. And then if one goes over the page 1346, Lord Scott of Foscott spoke. He said, right at the beginning of of what he said, both these instruments raise different discrete points, but they have one factor in common. They both raise questions about access to justice. Access to justice in the civil justice system is critical. Of what use is a justice system if it's not available to the citizens whose rights are to be protected or are to be defended against allegations that they've broken other people's rights? And then on page 1347, he looks at the at the percentage uplift, and he concludes in the last paragraph of what he said, 10% is with respect to ridiculous rate, would deny access to justice to a whole range of people who will not be able to afford to litigate, would be in denial of the whole purpose of the civil justice system, which is to discourage self-help, would also be apt to promote a deserved disrespect for the law. The noble Lord Martin has tabled a motion of regret, which I'd support. I also say that this is an instrument which ought to be withdrawn and rethought with proper evidence and full consultation. But those were not the only views, because as one sees, the learned friend Lord Panic came to the rescue, making some points which he later was to make to the European Court of Human Rights on behalf of Mirror Group newspapers. And that's, I think, as much as I need say about the landscape as at the date of MGN the UK. The judgment in MGN in UK was in January 2011, and it, as we mentioned in our case, coincidentally, that was the same month in which the police investigation into phone hacking at Newsgroup newspapers was reopened. And Newsgroup newspapers dropped the pretense that phone hacking was an isolated incident by a rogue reporter. Fairly quickly after that, and the way in which it's put Lord Justice by Leveson in his report, is that after that the case unravelled. It all started to come to light. So this is all in a sense hidden at the time that the Strasbourg court was looking at this. On the 13th of July 2011, your Lordship should have found before you a chronology, which I hope is a helpful document rather than one that simply adds to your Lordship's burden. But it has all the relevant dates in it and also the bundled references.
Thank you.
And your Lordship will see that on the second page of it, one gets on the 18th of January, the judgment being handed down in MGN UK, and then one has the various events that happened thereafter. On the 13th of July, the inquiry into press practices was announced, and on the 28th of July, Lord Justice Leveson was appointed. In the meantime, on the 21st of June, LASPO got its first reading. LASPO was designed to introduce the Jackson reforms. And if I could, we have looked at parts of this already, but if I could just look at a couple of bits of the Jackson final report, which is in volume 5, tab 3. Yes.
Yep.
I think I've got a wrong reference here.
Volume 5, tab 3.
Oh, tab 3, I'm so sorry. Yeah, right.
Page 1407.
Yes. Page 1406.
Yep.
If one starts at, this is the paragraph of Lord Justice Jackson's report dealing with defamation and related claims. Paragraph 1.7, he says that in relation to costs, he's in agreement with some of the English Pen and Index on censorship conclusions. In particular, I consider that success fees and after the event insurance premiums should cease to be recoverable. However, I consider that if this step is to be taken, other measures must be put in place in order to ensure that claimants have access to justice. So one sees that it's not just simply a question, the problem is not all resolved by striking down additional liabilities. Something has to be put into its place. And then on page 1412, I think he comes to the CFA regime. And page 1413 at paragraph 3.7, he says that in many but not all cases there are strong policy reasons why the claimant should be protected against liability for adverse costs. This is because in the paradigm libel case, the claimant is an individual of modest means and the defendant is a well-resourced media organisation. That is not the universal case, but it is the normal case. And then there is the paragraph about the most bizarre and expensive system, which, as your lordship see, comes under the ATE insurance head rather than the success fees head. I think that's probably what I need from Lord Justice Jackson. On the So his recommendation was that for defamation and privacy claims, that damages should be increased by 10%, with success fees to be paid by claimants, and that cost protection should be achieved by qualified one-way cost shifting. Now, whether that would meet the requirements of access to justice is certainly not for me to inquire, but it's a good deal better than what your lordships are invited to do. 2012, on the 1st of May, LASPO received royal assent ending recovery of success fees and additional liabilities. I needn't take your lordships to that, except to ask your lordships to note that it is expressly stated in both sections that they're not to be retroactive. Right. The reason why in no measures for access to justice in publication cases were included in LASPO was given by the Minister in March 2012, and this is at volume 4, tab 34. At starting on page 1351, this is part of the debate on LASPO in the Lords.
Yep.
Paragraph 1352, Lord McNally, the Minister, says, we are doing, top of the page, we're doing what they did. We're bringing forward a defamation bill that will address many of these problems. Then jumping a couple of paragraphs, as I've already said, the legislation in this bill, that is LASPO, doesn't come into effect until 2013. The defamation bill and the procedural reforms that we intend to take forward with it are, of course, about reducing the complexity and therefore the expense involved. And all of those aims to be achieved, we'll look at the rules on cost protection for defamation and privacy proceedings when the defamation reforms come into effect. I can give the House the assurance that we will do so. And then Lord Leicester said, is the Minister saying that there will be adequate powers either under existing law to create, or under the future legislation to create any cost changes that are needed to secure a level playing field and equality of arms? If that's what he's saying, I'm completely satisfied. Answer, that is precisely what I'm saying. So that's why the provisions for publication cases were not included in LASPO. Then, shortly after that, the defamation bill, on the 10th of May, the defamation bill got its first reading. Attempts were made during its passage to introduce clauses to secure access to justice and cost protection. And in the course of its passages, Lord McNally's assurances were repeated. I won't take your lordships to them, but for lordship's note, they were repeated. Volume 4, tabs 35, 36, and 37. The Defamation Act received a royal assent in 25th of April 2013, and that has done quite a lot for defendants in defamation cases. Some of the provisions are noted in my learned friend Mr. McCormick's case in Miller at paragraph 50. I'd simply mentioned two. One is the effective abolition of juries, which has made quite a large impact on costs in these cases, because not just because jury trials are inherently more expensive, partly because you have to take the witness through their evidence in chief, and for other reasons, but more particularly in defamation cases, because it finally broke the logjam in which we had been prevented from going to the judge right at the start of the case and saying, well, will you give us a decision on what the words complained of mean? That very often breaks the logjam, because after that it's absolutely clear whether it can become clear whether the defendant's going to be in a position to justify, and it affects. And you can ask the judge, for example, to say, well, will you rule whether it's comment, and all matters which previously had been the province of the jury, and so which everybody was in ignorance of till the trial. The other provision in the Defamation Act, which I'd mention, is Section 1, which introduces a serious harm test for individuals and a serious financial loss test for corporations, trading corporations. That has winnowed out quite a lot of claims, and again, that is an issue that is typically taken right at the outset of the case, so that so that if you're going to fail on that, you fail right at the start. So I'm not suggesting that any of these things have got rid of the problems to which additional liabilities give rise, but they have ameliorated them. There is no imperfect system. So I've jumped ahead to royal assent of the Defamation Bill. In November 2012, the Parliamentary Joint Committee on Human Rights reported or reached its conclusion on the human rights issues raised by the Defamation Bill and reforms. And if I just draw your Lordship's attention to some passages from that. That's volume 5, tab 12, starting at page 1578. This is a joint committee of both houses. And the passage that I want to draw attention to are on page 1602. Paragraph 68, we're concerned that this change, that is LASPO, to CFAs and ATE may inhibit access to justice for those claimants and defendants who are middle income, but not eligible for legal aid. Well, for the most part, legal aid is not available in these cases at all now. We're particularly concerned that the reforms in the LASPO Act do not tackle this issue, as the present rules on CFAs may prevent claimants and defendants of modest means from accessing the courts, a particularly pertinent concern when the action is one of defamation. We note the government's ongoing effort to address this particular issue, ongoing consideration of the cost protection issue, remind the government that the solution to the difficulty faced by middle-income claimants and defendants is necessary if defamation reform is to be effective, so that all persons can access justice in defamation proceedings. So one can see that there's a strong parliamentary push for access to justice. That separately, there was another joint committee looking at the Joint Committee on the Defamation Bill. That's in the same volume at tab 9. And I think that what one has in fact, volume 5, tab 9, is one has an extract from Leveson, but in fact the only quote that we've got in the bundles from the Joint Committee is on page 1543.
Paragraph 3.9, yeah.
Yeah, paragraph 3.9. There's a quote from the Joint Committee, which your Lordships can skim through. The committee is again concerned about access to justice and cost protection in defamation cases. Then on the 29th of November 2012, the Leveson report was published. What it showed, we have summarised in our case, for example, at paragraph 57. It's the problem with press misconduct in this country. It was not confined to phone hacking, nor did it start with phone hacking. I'm not going to read out those bits. Your Lordships will have seen them. The problems in certain sections of the press are serious, and they were only exposed because of civil lawsuits, and those civil lawsuits were, for the most part, only made possible by CFAs. The only other...
I'm just looking at 1543, the Joint Committee. Have I understood it correctly? They seem to be treating the system which still applies to defamation, namely a potential CFA of 100% success fee, as detrimental to access to justice.
Well, I think they...
They say this cap doesn't apply to other civil claims, that's civil claims other than personal injury, leaving the existing costs associated with 100% success fees in place. And they seem to treat that as detrimental to access.
Is that what they're saying?
Well, doesn't apply to apply to defamation or Lord Justice Jackson's proposals that protect access to justice. For example, the cap won't apply. So they seem to treat
Well, yes.
cap as they seem to treat Lord Jackson's proposals as more protective of access to justice than the existing scheme. Well,
Yes, I see that. Essentially, it doesn't seem possible that they could have taken that view.
well,
He says that they say that we don't believe the 10% increase in damage would be enough to make a difference. Then the Cox.
they seem to think that 10% comes on top of the 100% success fee as well.
There does seem to be.
I don't think it's a very
lack of understanding.
I'm not sure. Seems to be a bit out of line with.
Yes, yes. Publication of Leveson, two things, which I won't go on about, press misconduct over the years, and then in another part of his report, which isn't in the volumes, which is quoted, paragraph 59 of our case. It's his conclusion that that if nothing was done, the problems would re-emerge. There is something of a tendency on the part, understandable tendency on the part of the press now to say, oh, well, all that was very wrong, but it's all in the past. And so let's put it behind us and get on. But what Lord Justice Leveson did was to trace the history of press regulation since the Second World War and to demonstrate that there was a repeating cycle of lapsing into misconduct, followed by a royal commission or an inquiry, followed by promises by the press to reform, followed by a few years later the same cycle repeating itself. As regards Levison's, the Levison report, again, I'm not going to take your lordships to very much of it, but if I could ask your lordships to go to volume 5, tab 9 again, starting at page 1536. Which is a chapter on the civil law. In paragraph 1.3, Levison says this chapter is not intended to repeat the analysis of the way in which the substantive laws developed, rather to deal with the problems facing those who seek to enforce their rights. It concerns the complexity of the process of civil law and the availability of otherwise of funding. And over the page, 1537, 2.4, in the context of this inquiry, this straightforward means of obtaining access to justice he's referring to, acting in person, is of very limited assistance because actions in defamation can only be commenced in the High Court. It's unusual for such claims to be removed to the County Court, and even more unlikely they will ever be considered for small claims. The real problem is that there are a large number of types of claim that are too complicated to self-help. Many, particularly in the area of media law, require legal help and even ingenuity to pursue. Lawyers then become essential. Those who of sufficient personal wealth can afford it, but those who are not cannot. For them, a different mechanism was provided in the form of the CFA. And then bottom of page 1538, as Levison referred to the Jackson Review. Page 1540, bottom of the page 2.17, he's referring to LASPO. These provisions, due to come into force on the 1st of April 2013, undoubtedly remove the concern expressed by the European Court of Human Rights and MGN in UK. They will also dramatically affect the balance of the relationship between those who wish to complain about press conduct and the press.
Sorry, where are you reading then?
That's page paragraph 2.17 on page 1540.
Yes, I'm with you. Thank you.
That, of course, is assuming commencement for defamation.
Yes. 1541, paragraph 3.3. Third line, he mentions that legal aid was not available for libel and slander, which is undoubtedly, which was correct, always has been the case. This was before the days when CFA agreements were lawful, with the result that only the very rich, or at least those who could afford or were prepared to take the risk of a substantial cost liability of losing an action, were able to litigate. Power was very much in the hands of the press, who, by way of comparison, most potential litigants were well able to afford to litigate. They had in-house lawyers who were very familiar with the law, more than capable of advancing the case, except where a litigant was so wealthy that the risk was simply not a factor. That power was real, and must, of course, very many who felt aggrieved by the justice order and not by defamatory statements to refrain from seeking to pursue any remedy. And next page, paragraph 3.7, the change in the law enacted by LASPO will again alter the balance between those who complain and the press itself. If damages are comparatively modest and there's no prospect of recovering additional liabilities, the economics of litigation move against those who would otherwise challenge the press in favour of the press. That has not been lost on the victims. Many have given evidence to the effect that they've only been able to pursue a remedy against the news of the world because of the existence of the CFA regime, and that without it they would have been left without the wherewithal to pursue a claim for damages at all. And your lordship sees from the footnote at 17 that those victims included the Sally Dowler, who was the mother of the murdered child whose phone was hacked, Christopher Jeffries, who was vilified over a murder for which he was completely innocent, Jerry McCann, who was accused of, in effect, of being responsible for the abduction of his own daughter. And there were many such cases. 3.8, privacy claims and claims of the type that have been pursued against the News of the World are not necessarily straightforward. And in the absence of appropriate legal assistance, there is no question of equality of arms. The wealthy will be able to pursue a remedy in court, but there will be less incentive to lawyers to take up the cases. And on the basis that the AT insurance is not recovered, it will be much more expensive to litigate with protection. And in the absence of such protection, the risk of financial disaster may be real. I think my learned friend Mr. Panic read part of this. Then thereafter. So one sees how it's becoming absolutely clear how critical access to justice is, not merely to enable people to defend and assert their Article 8 rights, but to maintain press standards, because the fact appears to be that but for civil litigation, which was to a large extent enabled by the 1999 regime, it may be that the press misconduct would have continued. This is what, in fact, maintains press standards. So in this way, one can see that all these convention rights really should work hand in hand. I don't I have much more to look at.
Which is the other side of the coin, we're interested, didn't we? On the other hand, it's not difficult to understand the MGM objections.
Well, absolutely right, yes. I mean, nobody, least of all me, is trying to suggest that the current regime is perfect. It clearly isn't. And it can lead to very large cost claims, as your lordships have seen. 1544, 3.13.
What's your case? Your case is that, assume that the problems for the press exist, still at least your clients don't have problems, and that's a legitimate balance, or is it just a balance we can't do anything? I mean, that doesn't seem to be what the Jackson report is saying, of course.
Well, no. What I'm saying, in the end, my submission is that if one looks at what has come to the fore since MGN UK has decided, one can see that the balance between Article 10 and Article 8 is, however imperfectly, held by the regime of additional liabilities, and that this court should uphold it.
Yes, and you're saying that if we were to strike down the additional liabilities, we might get out of an Article 10 frying pan, but into an Article 8 fire.
Precisely so.
Yes.
Paragraph 15, page 1544, my learned friend Lord Panic read 3.1, paragraph 3.13, and I think there's only one more passage that I want to look at, page 1549, paragraph 6.1, under the heading Costs. The impact over the years of different funding arrangements, as described above, the government has made clear its concerns around access to justice and the ability of those with modest means to pursue claims against often powerful media organisations. The recommendations made by Lord Justice Jackson for Quox have not to date found favour. As the Joint Committee observed, access to justice must be maintained for all citizens seeking to protect their right to privacy. In the light of the very real difficulties facing those seeking access to justice, I have no doubt that a regulator needs to provide a speedy, effective and cost-free regime which provides a mechanism. And of course that regime has now been introduced, but the press are not interested in it. And finally, page 1551, paragraph 6.10. It's obviously necessary to consider the alternative. That's the alternative if there isn't an independent regulator. providing an acceptable alternative mechanism for the resolution of disputes. It's here that I share the very real concern expressed by the Joint Committee in relation to access to justice. The prospect of returning to a system whereby any of the very rich could pursue defamation, breaches of privacy and confidence or other claims and tort against publishers because of the potential cost consequences would, in my view, be a seriously retrograde step in our attempts to provide justice for all. In my view, it's simply not acceptable. The very least that can be done would be revert to the scheme proposed by Lord Justice Jackson. Well, one may have views on whether the Lord Justice Jackson scheme is preferable to the present scheme, but that is not what the government has, at least temporarily, decided. So, Leveson is published on the 29th of November, and that prompts an immediate change of heart on the part of the government, which one sees in volume 4 at tab 38. Page 1363, the minister in the middle of the page.
Sorry, which 28? Which one?
38.
Volume
The last tab of
4.
volume 4. Yep, okay.
Tab 38, last tab,
Yep, thank you.
last page, page 1363.
Right, thank you.
1353.
63.
Yes, thank you.
So this is only, I think, less than a fortnight after Leveson is published. The Minister makes this announcement. In the context of his inquiry, Lord Justice Leveson recommended that cost protection should be extended to defamation and privacy claims. This would mean that individuals of modest means should not be in the position of bringing or defending action without some form of protection against having to pay the other side's costs. The government have accepted this recommendation and therefore today announcing that the LASPO provisions will not come into force for defamation and privacy claims until cost protection has been introduced for these proceedings. The government has already asked the Civil Justice Council for advice. This short delay in implementation will mean the protection which currently exists through recoverable insurance premiums will continue until a new regime of cost protection can be implemented. So what your lordships are invited to do is, in effect, to commence sections 44 and 46 of LASPO and to do so retrospectively at a time when there is no alternative cost protection provided. So it's a somewhat drastic course that your lordships are being asked to take when all of this is intensely difficult and is under consideration by the government and others. That was then that course was implemented when the LASPO commencement order was made. That is in volume 4 at tab 14. I think your lordship has probably already seen that, but what one sees is that it accepts defamation, privacy and other publication cases from the commencement of LASPO. On the 28th of March, then, the Civil Justice Council Defamation Costs Working Group published its report. Your lordships have seen parts of that. It's in volume 5. I'm not going to take your lordships to very much of this. Volume 5 at tab 13, page 1616.
Yep.
And here, the defamation working group, your lordships can see its membership on page 1622, which was a range of experts, including in-house lawyers from national newspapers. What they eventually came down to, one can see on page 1637, 7.2, the majority of the working group was in agreement that a variation on quox would be the most appropriate type of mechanism for use in these types of proceedings. In fact, it was a quox that could work either way, because either the claimant or the defendant could claim to be protected against the other side's costs, and the judge would, if there was a dispute about it, the judge would have to decide whether the claimant, if he was the applicant, or the defendant, if he was the applicant, would get cost protection. So it was a sort of a variation on the qualified one-way cost shifting that's been introduced in personal injuries cases. I think that's probably all that needs to be said about that. That was on the 28th of March. The next thing that happened was that on the 25th of April 2013, the Crime and Courts Act was given royal assent. This was the vehicle with the Royal Charter for implementing Lord Justice Leveson's proposal that access to justice should be secured by an arbitration scheme of a recognised independent regulator, with costs provisions to provide an incentive to go to arbitration rather than litigation. This is in volume 4 at tab 11. It might just be worth glancing at it. Volume 4, tab 11. The first section that we have there is section 34, which is in force. It was brought into force on the 3rd of November 2015. And provides that exemplary damages on subsection 2, exemplary damages may not be awarded against the defendant if the defendant was a member of an approved regulator. And then it goes on to say, to explain the circumstances in which the exemplary damages could be awarded, which is not terribly different from the present situation. But there's an immunity from exemplary damages if you're a member of an approved regulator. And then the contentious section is section 40, which is not yet in force, but which is vigorously opposed by the press, which in effect provides, section 2, if the defendant was a member of an approved regulator, the court must not award costs against the defendant unless satisfied that the issues couldn't have been covered by the arbitration scheme, and it's just and equitable. So defendants who are a member of approved regulators get immunity, subject to the discretion in the court, from costs. But subsection 3, if the defendant was not a member of an approved regulator, the court must award costs against the defendant unless the issues in the claim couldn't have been resolved by the arbitration scheme, or it's just and equitable to make a different award. So, in effect, the party responsible for preventing the case going to arbitration pays the costs.
Win, lose or draw. Win, lose or draw.
Yes, that's right. The rule is go to arbitration, and if you choose to litigate, you will have to pay for it. Subsection 4, so I find somewhat Delphic, but the Secretary of State must take steps to put in place arrangements for protecting the position and costs of parties to relevant claims who have entered into agreements under Section 58 of the CLSA, which is the section that permits CFAs. And subsection 6, the section doesn't apply until a body is first recognised as an approved regulator. Then
How does subsection 4 work?
I'm afraid the short answer to that is I simply don't know.
Is it an expression of a pious wish, or
I'm sorry, Mark?
is it the expression of a pious wish? So they must take steps to put in place arrangements. For
Yes.
No time scale, nothing. And it presumably depends obviously of the section. But are we to understand that if the section were brought into force, he would have to act within a reasonable time? Otherwise, he'd be in breach of a statutory duty. Is that the...
I'm afraid I simply don't know, because it's not at all clear to me what sort of arrangements the Secretary of State is to put into place. But at all events, what we have here is the Leveson regime for arbitration under the auspices of an approved regulator, together with an incentive, a strong incentive in Section 40, and the whole of that has been opposed by the press. The next thing, that was in April 2000, the next thing in September 2013 is that the Ministry of Justice consulted on cost protection in defamation and privacy cases. That's in volume 5 at tab 14. If I can perhaps explain what I understand to be the aim of these rather complicated arrangements. Section 40 of the Crime and Courts Act provides a regime of cost protection for defendants who are members of approved regulators. But not all defendant publishers are covered by that, because some of them can't be, and for some of them it's not reasonable for them to be a member of an approved regulator. And so this is designed for cases to which Section 40 doesn't apply. And I think one sees that from paragraphs 21 and 22 of on page 1674.
Yeah.
22, cost protection will be available to both claimants and defendants, subject to satisfying the tests below. However, when it comes into effect, Section 40 of the Crime and Courts Act will take precedence over any consideration of an application for costs protection.
What is meant in that context by cost protection?
Well, I think one sees that in the government's proposals. If one can I start at the foreword, page 1669, where there's a picture of the minister. It's important that people of modest means should be able to bring and defend defamation of privacy claims. The government has accepted the separate recommendations of Lord Justice Jackson and Lord Justice Leveson to reform civil litigation funding and to make civil costs more proportionate. We've already introduced reforms to no-win, no-fee agreements in most categories, but not yet to defamation of privacy. However, we've said that we will extend the no-win, no-fee reforms to defamation and privacy. That's LASPO, when we can implement a cost protection regime which will protect poorer parties, both claimants and defendants. So this is what's going to come in along with the implementation of LASPO. And the summary of the government's proposals is on page 1679. The rules which should apply to protect the costs that a party might have to pay to the other side. In other words, these are cases in which a party doesn't have to pay the other side's costs, those of substantial means would be excluded from the cost protection regime. Those of lesser means could get cost protection, either in full. Those of modest means would not have to pay anything, or in part. Those of less modest means might have to pay a reasonable sum capped to the maximum amount.
Cost cap system, is it?
Well, it's either a total
Looks like it.
it's either total protection.
Well, yes, sometimes the cap's nil.
Yes, exactly.
Yes.
Exactly. The claimant of modest means to be able to get cost protection, be open to a party to agree, otherwise the judge decides based on the applicant's means and the costs which he or she might be able to pay. So that's what's consulted on. That consultation ended in November 2013, but as yet we don't know what the outcome of it is. The Royal Charter came into force, was granted by the Privy Council on the 30th of October 2013. That's in volume 4 at tab 16. Your Lordship sees that in the preamble, the Leveson inquiry is referred to, and just below the bottom, the middle of the page, the report of the inquiry recommended that all those parts of the press which are significant news publishers become members of a regulatory body. And then next, jumping one, the report of the inquiry recommended a mechanism to recognise. This sets up, in effect, simply the mechanism for the recognition panel, which is to recognise the regulator, and in accordance with the recognition criteria are at pages 1159 and following. I needn't trouble your Lordships with them, just to point out that many of them refer to the need for the regulator to be independent of the press and of Parliament and of government. I think all of those paragraphs 1 to 7 of the recognition criteria are to do with independence. And then 1163, page 1163, paragraph 22, the board of the regulator has to provide an arbitral process for civil legal claims against subscribers, which is free for the complainants and ensures the parties should each bear their own costs or expenses subject to a complainant's costs or expenses being recoverable. Overall is inexpensive. So that's the Royal Charter. So one sees that the government moving to implement the Lord Justice Leveson's proposals. The recognition panel came into existence in November 2014. And all of what I'm going through helps to explain the delay in dealing with and replacing the current system. It's not a short or easy task. In response to Leveson, the press set up IPSO as a complaints handling body or regulator. It's not recognised. It doesn't pretend that it could be. It hasn't applied to be recognised, not least because it is not independent of the press. Impress, the independent monitor for the press, was also set up and applied for recognition and was recognised on the 25th of October 2016, thus triggering Section 46 of the Crime and Courts Act. So that will be effective if and when it's brought into force.
Yep.
So Section 40 has become a hot potato. And on the 1st of November, the Department of Culture, Media and Sport launched a consultation. I think we may have looked at some paragraphs of this. It's at volume 5, tab 15. I think one looks at the foreword on page 1704, seeking views for the public on the different options for commencement of Section 40 of the Crime and Courts Act, and whether to proceed with Part 2 of Leveson, which is the part of Leveson which is supposed to deal with the relations between the press and the police.
Yep.
These issues are too important not to consult on. We're aware of the strength of feeling and so on and so forth. And the options are pretty straightforward. And one sees at paragraph 1715 onwards either keep Section 40 under review.
Sorry, which page?
Sorry, 1715.
Yeah.
Options. Option 1, keep Section 40 under review. 2, fully commence it. 3, repeal it. And over the page 4, partially commence it. Commence only those subsections that would give protections to members of a recognised self-regulator. And then my learned friend Lord Panic read paragraph 50.
Yep.
That consultation finished on the 10th of January and is subject to a pending judicial review. So the present position is that we don't have a decision on implementing Section 40 of the Crime and Courts Act. We don't have a decision on implementing the sections of LASPO. We don't have a decision on a regime of costs protection. Now, the upshot of it all is that, first of all, it's become apparent that there is a pressing social need for access to justice to protect Article 8 rights. Secondly, the process of balancing the rights is intensely difficult and controversial. And now, we say, is not the time for the courts to step in to the breach and in effect, implement LASPO retroactively. And we say that if the Strasbourg court were looking at the position again now, it would pay close attention and respect to the difficult democratic process that is underway amid intense lobbying and controversy, and would say that the present system, although imperfect, is an acceptable method of balancing the rights in process for at least temporarily. One presumes that at some stage, one hopes shortly, when the judicial review is over, that we will get a government decision, and that may change matters again. So, my lords, that's the review of what's happened. I don't...
I'd say that this process of getting reports and having consultations and making statements, which involved at least 2 major reports and about 6 to 10 consultations or statements, could go on forever. And maybe someone should actually take the bull by the horns and say that this whole scheme is clearly unacceptable, and that will no doubt lead to a claim by anyone who has a legitimate expectation in Strasbourg. I mean, it does seem to be common ground that the present system is unacceptable. The problem is that nobody is really determined to implement any other scheme. It's not entirely clear to me why not.
Yes, I mean, I can see obviously why your lordship says that, but it may be a little unfair. The fact is that it's taken a long time for the extravagant press misconduct to be brought to light, and for the difficult process of consultation and so forth to proceed. If the press had at any point indicated that it would be prepared to accept, for example, Section 40 of the Crime and Courts Act, or that it would accept quox or something of that kind, or if it had not necessarily signed up to impress, it doesn't seem to like impress much, but have arranged matters that ipso is convention compliant, which could, is Leveson compliant, which could undoubtedly be done, well then they would leap free of the whole system which they presently, it can fairly be said that much of both the delay and the reason why they're still in this bind is down to them. My Lord, as regards the facts of the flood case, the particular facts, the ones that matter are that I think this is in paragraph 74 and 75 of our case, is that first of all, the flood CFAs are not CFA light. In other words, if the success fees are not recoverable from the defendant, they are, in law, recoverable from Mr. Flood. Whether the lawyers involved would be merciful is no doubt a matter for them. But it's a slender basis on which to potentially breach someone's Article 1, Protocol 1 right. Yep. The ATE premium has already been paid, and the money to do so has been borrowed. One sees that in paragraph 75. This is one of the methods of financing it. If it's not recoverable from the defendant, Mr. Flood will have to repay Justice Capital Limited, from whom it has been borrowed. And the only other point, factual matter, all of the CFAs in this case were entered into after the House of Lords upheld the scheme in the Campbell case, but before MGN and UK.
Right.
And we say that's powerful or more than powerful on legitimate expectations. My Lord, I finished a little bit early, but my learned friends have a lot to cover.
Thank you very much indeed. Thank you very much, Mr. Price. Mr. Bennett.
I have no submissions, my lord.
Very much. Mr. McCormick.
My Lords, can I start by hopefully dealing with a few questions that may have been left hanging in no particular order. I think my Lord Hughes inquired about the extent of quox and the financial exception there might be to quox, because that was how Lord Justice Jackson framed his recommendation. As implemented in personal injury cases, there's no financial qualification at all. It's a conduct-based qualification. If the case is struck out as an abusive process, or if there's, I can't remember the precise wording, but something that amounts to serious dishonesty, fundamental dishonesty in the way the case is pursued, then quox does not apply and a costs order may be made against the claimant.
But otherwise, claimants litigate free.
More or less, yes, my Lord, yes. It's not the sort of means-based test in any way that was originally suggested by the Civil Justice Council Joint Working Party and subsequently was apparently the government's preferred method in the most recent consultation.
Thank you.
Turning then to the some questions posed by my Lord Mance to Mr. Price on the troubling paragraph in the Leveson inquiry report, bundle 5, tab 9, page 1543. this is where we find the excerpt from the joint committee. And Lord Mance is saying, well, this looks as if they're saying have the 10% on top of the 100% or something like it. And I think the way in which this particular circle is squared, we're concerned defamation law will become even less accessible because the government doesn't plan to apply to defamation all Lord Justice Jackson's proposals that protect access to justice. For example, in respect of personal injury claims, there will be a cap on the amount that can be charged by lawyers as a success fee of 25% of the damages awarded. This cap doesn't apply to other civil claims, leaving the existing costs associated with 100% success fees in place. Now, that's the success fee that the client can agree to pay to the lawyers. It's not a recoverable success fee from the other side. In personal injury claims, because Lord Justice Jackson considered that personal injury claimants were, first of all, the people most likely to be affected by his reforms and possibly more vulnerable on average than others, it was thought necessary to ensure that they weren't going to give up more than 25% of their damages, and even then, only of damages which had crystallised by trial. It didn't include any of the future losses that make up the vast majority of the big claims. And therefore, there was a limit on how much could be claimed by lawyers from their own clients. And that 25% would be funded, hypothetically, out of the 10% additional general damages award that was reflected in Simmons and Castle. Whether or not it can actually do that is a matter for debate elsewhere, but that's the system that was set up. So in my submission, there's nothing irreconcilable with that, although I see my explanation may not have entirely convinced my Lord Mance.
Well, how do you explain defamation law will become even less accessible because government is going to leave 100% success fees recoverable and
No, not recoverable.
Well,
That's the point.
in place.
Well,
Chargeable but not recoverable.
well, chargeable, not recoverable, but not recoverable inter partes, recoverable solicitor and own client.
Yeah.
But I think there may be an acknowledgement there my Lord, that even as it stands at present, there are problems with some problems with access to justice in defamation, although they may be far less than they would be, depending on the outcome of this case. But in terms of...
Where is the proposal? I mean, I take the point now. I see how it works, but where do we find the proposal to allow 100% success fees to be charged as between client and lawyer, but not to be recoverable from the other side?
Well, we don't see that there because there's no proposal to allow that. That's already allowed, and there's no suggestion that that would be removed. It would simply be a matter for the clients and the solicitors to negotiate between themselves, and it is assumed that when a solicitor properly explains to a client, you can agree 100% with me, but you're only ever going to get 10% back from the other side, or you won't get anything back from the other side. There will be a renegotiation, and 10% would be the cap. And of course, this is against the background of the then previous government's attempt to cap success fees at 10% in any event.
Yep.
It's the context, and it's against the background of the Committee for Culture, Media and Sports recommendation that you could have a success fee at any level up to 100%, but only 10% would be recoverable from the defendant. It's against that background. But it certainly doesn't mean what my Lord Mance thought it might have meant, which is probably as far as I need to go at this stage. Can I, while we're on that page, though, take your lordships to the following paragraph, 310, because it sets out the government's response to the Joint Committee's concern. And in my submission, it's instructive. Current CFA regime with recoverable success fees and AT insurance has led to high costs across all areas of civil litigation, particular concerns in defamation and privacy cases. These high and disproportionate costs hinder access to justice and can lead to a chilling effect on journalism and academic and scientific debate. There's then reference to the MGN and UK case, which found existing CFA arrangements on recoverability in that particular case to be contrary to Article 10 of the Convention. Changes to the existing regime are therefore necessary. The government is aware of concerns around access to justice and the ability of those with modest means to pursue claims against often powerful media organisations. However, we do not believe it's necessary to make any special provision in relation to the costs of privacy or defamation proceedings. As the committee recognises, these claimants will benefit from a 10% increase in general damages. Government will continue to monitor the position, etc., etc. So, in response to the committee's concerns about access to justice, the government's response is, we're not going to do anything. We're not going to permit there to be success fees, recoverable inter partes, and a 10% increase in damages is going to adequately fill the hole left by recoverable success fees. Now, in the committee's submission to government, middle of the previous page, it makes clear that the average level of damages in defamation cases is no more than £40,000. So, if one uplifts that by 10%, it suggests that the access to justice problem in terms of irrecoverable uplifts is going to be met by an average of £4,000, to include any VAT, of course. So we're talking about £3,500 or less as the success fee agreed between the client and the solicitor in respect of defamation and privacy cases. Now, the other point I make, with less arithmetic in it, is the government's response doesn't recognise at all what we say is an extremely powerful Article 10 right in defendants, which is in favour of maintaining the present system over abolishing it as the present appellants wish you to. And the reasoning is this. The three appellants who are here are, for want of a more elegant phrase, well able to look after themselves. They do not have the advantage of the respondents in the Lawrence case, as recorded in the judgment, I think, of Lord Mans, that it was said that they were uninsured and of modest means. That can't sensibly apply to any of these three appellants. Mr. Rampton, in opening this case to you, reflected on the fact that in the 21st century, there are many other ways in which information is disseminated around society. Citizen journalism is the lazy phrase. Individuals have the right of freedom of expression every bit as much as associated newspapers. When an individual is sued for defamation, how is that individual to vindicate his or her Article 10 right? How is that person's Article 10 right not to be chilled by the threat of being sued by someone who can afford to let loose lawyers upon him or her? The way in which that has been achieved over the last 17 years is by allowing that defendant to find lawyers who will act on a CFA and, if possible, to find an ATE insurance policy. We say that is a fundamental component of the balancing of the rights that is in play here. And it is a factor which the appellants simply do not grapple with. Mr. Rampton touched upon it, but this is not a simple case of one right against another. There are many rights, there's a basket of rights, some of which work on an individual level, some of which work on a far wider societal level. These rights do not, Mr. Price said these rights may go hand in hand. In this case, many of them don't. Many of them conflict, and they need to be reconciled or balanced. But if Article 10 is, as the appellants tend to suggest, something that needs careful scrutiny, it needs careful scrutiny for those who require CFAs and ATE to vindicate their rights and to continue to publish with confidence, every bit as much as the rights of the three powerful, rich organisations who are before you today.
Is there evidence of such actions against the kind of individual publicists that you have in mind?
My Lord, I'm pleased you asked that. It's at Annex 2 of our written case. I use the phrase evidence loosely, of course. But
yes, you do.
I do, yes. What we've done, it's at page 684 of Volume 2.
That's what that is.
What we've done is we have an Annex 2. The first 2 pages relate to worthy claimants. But, well, I see my Lord's expression, and I appreciate that they may have a less valid claim, but they are the sort of people that Mr. Price referred to, who were vilified roundly, the subject of a feeding frenzy, and who are the paradigm examples of people who need access to justice. But taking my Lord's point, 684, we have set out in tabular form cases of which we are aware in which a defendant has vindicated Article 10 rights using CFAs and or ATE. And if I can draw particular attention to 3 of the cases. At the bottom of 684, NMT Medical against Peter Wilmshurst. And the reason I'm going to pick on the 3 cases, they are the troika of cases that proved the lightning rod for what became known as the libel reform movement, which culminated in the 2013 Act. And what we had here was a scientist, or someone who'd made a criticism at a medical lecture in the USA about a medical device. And he found himself on the wrong end of a libel suit from the manufacturer. And as the right-hand column explains, having failed to get legal aid under a Steele and Morris application, he ended up using his own savings and then a CFA. Top of the next page, similar position, GE Healthcare against Henrik Thompson. And again, it's a presentation given in Oxford, management in radiology relating to a medical device. And what was clearly a legitimate matter for public debate. And he's used the CFA in that case, which results in a confidential settlement. Then, if we skip down to the 3rd case on that same page, 685, we come to a case with which my Lord, the Lord President may recall he was involved in the judgment. And this was the one that really, well, I say caught the public imagination, I put it a little highly, but it was the one that really proved, he proved the poster boy for libel reform. It's an opinion piece in The Guardian in which he criticises the claims of chiropractors to be able to cure things like deafness in children and has a swipe at their professional body for promoting what he called bogus treatments. And he finds himself on the end of a libel writ. They don't sue the newspaper. They sue him personally as the author of the article. So he is left defending a libel action brought by the professional body for the country's chiropractors. There's no equality of arms there in terms of his wealth and resources. He has to find solicitors and counsel to defend himself. And for part of that case, he needed to use a CFA, and he did. And once my Lord and 2 of his brother judges had dismissed the claim in the Court of Appeal, or ruled that it was a comment piece in the Court of Appeal, the case was promptly discontinued. 2 others on at the bottom of that page, and this isn't part of the libel reform movement, but it is instructive. Thornton and the Telegraph. This is Telegraph newspapers instructing Mr. David Price, now Queen's Counsel, on a CFA to defend a claim brought against him by Sarah Thornton. This is a national media organisation who is using the CFA regime to defend itself, albeit unsuccessfully. Top of the next page, Reginald Mengi against Sarah Hermitage. The reason I'm drawing the court's attention to this is because it also features as part of the legitimate expectation argument.
So the CFA was used by the Telegraph?
It was. In that case, there were CFAs on both sides.
Right. On both sides.
Yes. And as Lord Panic suggests that in that sort of situation it goes on ad infinitum. It doesn't. It stops. If each side has an ATE policy, although they didn't in this case, and each side has a CFA, that's it. It happens on a not infrequent basis in other areas of the law. But in this case, Mengi and Hermitage, the defendant made an application for security for costs. It was heard by Mr. Justice Tugendhat, judge not unfamiliar with Article 10 and its implications, and he awarded security in the full sum of the uplifts available in that case. And in the end, she was able to vindicate her Article 10 rights using a CFA with the services, I think it was Mrs. Carter Ruck. And then the final one I'm going to mention, simply because it's actually very recent, it's in the middle of that page, it's Economou and De Freitas. This matter was tried in July of this year. And the case was the events were notorious at the time. A young lady who took her own life shortly before she was to be tried for perverting the course of justice in connection with an allegation of rape she'd made. And her father had been interviewed on the BBC Today programme and had made various comments about his concerns about the way in which these cases were dealt with by the Director of Public Prosecutions. And he found himself on the wrong end of a libel case from a member of a relatively wealthy family. And he needed to get a conditional fee agreement so that he could fund his defence. He didn't have an ATE policy, so he faced effectively financial ruin if he lost. But he had no other option. And he was successful at trial in front of Mr. Justice Warby in July of this year. So those are examples of cases where people have used their Article 10, this present regime, to vindicate their Article 10 rights, and where the regime proposed by Lord Justice Jackson simply won't accord them to access to justice anyway, for reasons that I'll come on to. And the proposal that your lordship should simply declare incompatible the entire scheme, leaving nothing, will have exactly the same effect.
What is the source from which the information in this appendix is derived?
From the collective recollection of counsel involved and solicitors involved. It's also, my lord, I appreciate there's no statement of truth at the bottom of it, but it's been shown, it's been available to all of the appellant's teams, some of whom were involved in some of these cases. There's been no challenge to its accuracy in any way whatsoever. So
better count as another report.
Well, to borrow from my Lord Hodge, if we are coming out of the frying pan, the fire into which you're being asked to step isn't just an Article 8 fire, it also has Article 10 burning brightly within it. While I'm on the subject of Article 10, in my submission, there is scope to regard the vindication by an individual of his Article 8 rights, and I refer in this case to my client, as serving Article 10. The reason is this. The Article 10 right, as Mr. Rampton observed at the start of these proceedings, involves the right of society in general to receive information. It's not simply the right to express, it's the right to receive information. And we know from Lord Hobhouse's remarks in the Reynolds case, which we've set out in our written case, that there's no public interest in misinformation being circulated. If I find the reference, I shall do so. Well, I'll come back to, sorry, James Heath. Sorry, I found it. Sorry, it's paragraph 42 of our written case at page 653 of volume 2, tab 6. Page 653 in volume 2 at tab 6. And it's short, so I'll read it for those who aren't there or don't feel inclined to go there. There is no human right to disseminate information that is not true. No public interest is served by publishing or communicating misinformation. The working of a democratic society depends on the members of that society being informed, not misinformed. Misleading people and purveying as fact statements which are not true is destructive of the democratic society and should form no part of such a society. There's no duty to publish what is not true. There is no interest in being misinformed. These are general propositions going far beyond the mere protection of reputations. And I would add, going far beyond concepts known only under the Convention on Human Rights. They're part and parcel of English law as well. Where a newspaper has published something that is false, has misinformed the public, and where that information in all probability will lie on the internet as part of the generally accessible repository of information, does it not serve Article 10 for an individual to bring that publisher to the point where it has to accept that what it published was misinformation and correct the public record, therefore ensuring that future persons are not misinformed by that article, and that those who were misinformed have a greater chance of being corrected. So in my submission, there is at least something of Article 10 to be weighed in the balance in that context as well. Now, that is not to say that the balance is easy to draw even then. This is an intractable problem so far. One hopes a solution can be found. But the suggestion that we are where we are, and therefore your Lordship should simply say none of these orders should be met for costs because the scheme was regarded as incompatible in 2005 in the MGN and UK case. We say that's simply wrong. The scheme is compatible because it holds in play a variety of rights, some of which were simply not considered by the European Court in the MGN and UK case. And I'll come on to that when I discharge the second of the tasks that Mr. Price has set me. The first of those tasks may not take me very long, because it may not be particularly important to your Lordships. It's what is the true ambit of Campbell number 2. It's clear the question was framed narrowly in the petition, but it's equally clear that in order to reach the result, the appellate committee took the route of deciding that the scheme was compatible with Article 10, and therefore it didn't need to descend upon the particulars. Now, one wasn't party to the submissions made, so one isn't sure how that situation evolved. But it is clear from the paragraphs 27 and 28 of Lord Hoffman's speech that that is the route that was taken. It is clear also from Lord Carswell, paragraph 55, where he said that expressly, he said, the only issue that the appellate committee was being asked to decide was one of principle. Now, it seems slightly surprising that he expressed himself in that way, bearing in mind the way in which the petition was actually framed. But it is clear that on any sensible view, this was a reasoned decision on the part of the appellate committee that the scheme was in fact compliant, and that was why they did not need to consider the factual scenario as it existed between Miss Campbell and Mirror Group newspapers. One consequence of that, if I can just give your Lordships the reference to it in Lord Hoffman's speech, paragraph 26 on page 2081. This, of course, is in Bundle 6, so it's Bundle 6, Tab 8, 2081. He records that Miss Campbell denies that she is so wealthy as to be able to view with equanimity the risk of having to pay both her own and MGN's costs of an appeal to the House of Lords. She says, probably with justification, that there can be few such individuals, but I think that it would not matter even if she demonstrably had ample means to pay. It seems to have become one of the accepted truths of this case that Miss Campbell could afford to pay. It's dangerous. This is one of many such instances in relation to this litigation, but there is no finding that she was able to pay. And of course, one's tempted to draw on general knowledge and remember how much it might have taken for Miss Campbell to get out of bed in the morning at one time in her career. But the reality here is there are many reasons why an individual who might be considered to be relatively well off might not be able to fund in the short term or at all a total cost bill of, let's call it £500,000 for her own costs and the other side's costs. And that's precisely one of the problems in putting any form of means test in play. But it can't be taken as read that Miss Campbell was rich enough that she didn't need a CFA. There is no finding to that effect, no evidence. On the basis that if your Lordships consider that the ratio is, as I have said, your Lordships are still free to depart from the case if you consider it appropriate. And whether or not the ratio was correctly interpreted by Mr. Justice Mitting or not, we are here in front of your lordships in any event. I'm going to leave that task there. But before I pass from the speech of Lord Hoffman, can I take you to the paragraph 29? So this is where, having decided the case, he feels the need to express various dicta.
Okay.
And it's to illustrate another of the misconceptions that has grown up around this case, in particular in the European Court's judgment. Yep. The case of Turku is referred to, and on page 2083, yep, paragraph 6 of that judgment of Mr. Justice Eadie. The entire case is elsewhere in the bundles, but I'm not taking your lordships to it, it's not necessary. And within paragraph 6 of Mr. Justice Eadie's judgment, he makes the point, and I'm looking at the last 8 lines, significant costs can be run up for the defendant without any prospect of recovery if they are successful. Since one of the matters on which Mr. Price does apparently have instructions is that his client is without funds. On the other hand, if the defendant is unsuccessful, it may be ordered to pay, quite apart from any damages, the costs of the claimant's solicitors, including a markup in respect of the success fee. The defendant's position is thus wholly unenviable. Faced with these circumstances, there must be a significant temptation for media defendants to pay up something to be rid of litigation for purely commercial reasons and without regard to the true merits of any defence. This is the so-called chilling effect or ransom factor inherent in the CFA system. Well, it's one form of the chill because it relates to the conduct of litigation rather than the conduct of the antecedent journalism. But it's one form. But it's not the form of chill that is in play in this case, in any of these 3 cases, because it's the specific no-win scenario chill. Because if the newspaper lost, it had to pay. If the newspaper won, it still had to pay, because it had to pay its own lawyers to win the case. It could never hope to get that money back. So it's a different, and it's a worse chill. Because what Mr. Justice Eadie was saying, well, in those circumstances, you can understand why any person and any journalistic organisation is going to say, well, look, it's going to cost us £200,000 to lose. It's going to cost us £150,000 to win. Why wouldn't we get rid of this case for £50,000? That's not the position we're in at this stage. And it's precisely the same chill. And that's what Lord Hoffman returns to in paragraph 31 at the top of the next page. It's the use, it's paragraph 31, top of 2084. The blackmailing effect of such litigation appears to arise from 2 factors. First, the use of CFAs by impecunious claimants who do not take out ATE insurance. That's the specific vice. That, of course, is not a feature of the present case. It wasn't. The second factor, and I'll deal with that while we're here, 4 lines further down. The second factor is the conduct of the case by the claimant's solicitors in a way which not only runs up substantial costs, but requires the defendant to do so as well. This is some form of supposed arms race. If I'm going to spend so much on disclosure, you're going to do the same. Now, I accept there is the temptation to retaliate in terms of counsel. We've got a junior, you've got a junior, we bring in a leader, you bring in a leader. So there is something in that. But this is now well and truly handled by costs management. This judgment, the speech has been delivered in 2005. The cost management pilot began on the 1st of October 2009, by which at a very early stage, the parties are required to set out how much they believe they should be able to spend on this case. And a judge then tells them how much they can actually recover from the other side. They can spend what they like, but what they're going to recover is carefully controlled. So both of now the first vice just doesn't apply here. The second vice doesn't apply in any case where there's cost management or anything approaching it. Just to make complete the submission, if we look at towards the bottom of 2084, we see paragraph 75 of Lord Justice Brooke's judgment in Musa King. Main complaint, this is the complaint made by the defendant, Telegraph Group. This is another area in which, in the context of litigation conducted by a claimant on a CFA without ATE cover, conduct of this kind is wholly out of place. So it's the same combination that is causing the problem. And over the page, paragraph 32, Lord Justice Brooke is sympathetic to the complaints about irrecoverable costs. What is an issue in this case is the appropriateness of arrangements whereby a defendant publisher will be required to pay up to twice the reasonable and proportionate costs of the claimant if he loses or concedes liability, and will almost certainly have to bear his own costs, estimated in that case to be about £400,000, if he wins.
Again, no ATE premium.
No ATE premium. And of course, the costs on the defendant's own side were not insubstantial, £400,000. And then finally on this point, in the middle of paragraph 34 down on that page, yes. It's however only a palliative, doesn't deal with the problem of a newspaper being faced with the prospect of incurring substantial and irrecoverable costs. And then on a different point, but the last point I make from this speech, paragraph 37 on the facing page, 2086.
Yep.
It's after there's been a discussion about the difference in the negotiating powers of the respective sides in the cost war between personal injury cases and defamation cases. Just below letter D, of course, one object of extending CFAs to defamation and breach of confidence claims was to enable people of modest means to protect their reputations and privacy from powerful publishers who previously didn't have to fear litigation, even if their publications were totally unjustified. Henceforward, they would be able to vindicate their rights, which are also convention rights, in the way that the rich and powerful have always been able to do. There may be more of these cases in the future. Finding ways of moderating the costs would then be in the best interest of all concerned, but the rich and the powerful have always had to pay the costs of failure. Finding ways of ensuring that impecunious claimant can do this may be more of a challenge. And without any criticism intended of Lord Hoffman, what's missing there is the problem of the impecunious defendant facing the libel action. Didn't arise in that case and clearly needed consideration later. Can I then take your lordships to what happened next? In terms of Lord Justice Jackson's report. Now, I'm aware I'm going to retread some ground Mr. Price's tread, but I'm going to put my feet in different places. I'm not going to have your lordships read anything that's already been read to them. Can I ask you, bundle 5, tab 3. I'm sorry, thank you. I heard Mr. Tomlinson. I thought he was uncharacteristically quiet all the time I was on my feet. The clock is 4:15, and if it's...
How long are you going to take us to the relevant parts of Jackson?
I'll be very quick now, my lord.
Why don't you do that?
Page 1407.
Thank you.
It's paragraph 1.2.
Yes.
And here, Lord Justice Jackson refers to an appendix to his provisional report.
Thank you.
And can I just ask your lordships to bear in mind, the report set out details of 154 libel and privacy claims brought against the media in 2008, yep. And which resulted in payments to claimants.
Yep.
And there's a reason why I'm doing it. It'll become apparent tomorrow morning. The next section is headed to wider debate. Mr. Price read 1.7. Can I just take you to 1.6?
Yes.
Lord Justice Jackson recognised there were wider issues, but said they weren't for him. Paragraph 2.1 on that page.
Yep, media lawyers.
Media lawyer submission. There are 5 points made. 1, success fees and ATE premium should cease to be recoverable. Jury's still out on that. Secondly, there should be more proactive early cost management. Tick for that, done since 1st of October 2009. Costs which are disproportionate to the amount involved and the nature of the claim should be irrecoverable. New proportionality should cover that.
So you say tick that.
Tick that. There should be procedural changes to facilitate early resolution of preliminary matters. Tick that. Abolition, effectively, of jury trial by Section 11 of the 2013 Act means that meaning, comment or fact, yes. Serious harm, dealt with very early. Thank you. My Lord, that's all I want to take you to in the Jackson report. But can I leave your lordships with this thought? The Jackson report is clearly a significant, substantial and important piece of work. What it did not address was costs of impecunious defendants and how their access to justice was going to be managed. Now, in certain areas of work, the reasoning was there, saying all but a very small proportion of cases are brought by small claimants against large defendants, typically personal injury, medical negligence cases. But it did not purport to address the more complicated issue in other areas of law about how you vindicate a defendant's rights. My Lord.
That's a convenient moment.
It certainly is, my Lord.
Good. Well, we'll resume again at 10 o'clock or else as soon thereafter as we can. Very much. Court's now adjourned until tomorrow.